Is a right. Give me a sec.
Sir, is it okay now? Abdul sir, fine, no?
Yeah, fine, fine.
Okay, fine. Yeah, please start, sir.
Yeah. You see, idea of a copyright. You work something or you do something, and that is your own invention. That is your own idea. As we saw in the last class, that ideas are protected. Ideas are protected by intellectual property rights. Now, ideas are the personal opinion or personal invention of a person. Though there is no patent for ideas, but like your thinking, your creativity matters a lot. Now, copyright, uh, which deals with literary and artistic works. Literary means the books you write, uh, as well as what is the artistic work, the drawings, the paintings, whatever you do. Now, most important aspect of this is Berne Convention. Under Berne Convention, everything would like got simplified. It was concluded in the year 1886 to protect the possible rights of the people who are doing works in copyright. Now, the main things which Berne Convention led to is national treatment. Like if I introduce something, and suppose a invention or a song is being written by me, or it is written by a foreigner, both the individual as well as the foreigner will be given the same kind of protection, national treatment. That is, though you are a national or a foreigner, your inventions will be protected. Your cinematograph work or your choreograph work or your artistic work or your literary work, everything is to be protected. Then once you make something, it gets an automatic protection. You need not to be going something which are with a very complex formality. It gives you automatically a protected right, that when you create something, you create a right with it. Then uh, WPO, World Intellectual Property Organization, had entered into a copyright treaty after Berne Convention, that is in the year 1886. World World Copyright Treaty, WCT. That copyright treaty had extended to computer programs as well as other complications, that is the data. For example, data we collect, computer data protection, data we collect, for that also the law made a protection to it. Then, according to World Copyright Treaty, there were three rights which are introduced: right to distribution, a right to rental, right to communication to public. These are the three exclusive right given to a person who has invented a thing. Now, see, World Intellectual Property Organization talks about performances in phonograms treaty. World Performance WIPO, Performance and Phonograms Treaty. Performance. What are performers? Performers are those who do stage performance. That is the singers, the musicians, then the producers, the phonograms. That is the person who fixed the sounds. There's a device called phonogram. In that device, you can manage the sounds, the sound recording and all. You can do it. The particular treaty obliges a contracting party for a legal remedy. That is, if I make any document, if I sing any song and somebody steals it, under this treaty, I can seek protection from the the law enforcing agency. Then next, I go to how a copyright is protected. how a copyright is protected, how far a protection is given. Now, that is section 13, clause 1 of Indian Copyright Act 1957, which, like, this Indian Copyright Act, which this act is taken from Berne Convention, the exact replica, that is the legal basis for forming this Indian Copyright Act is Berne Convention. They took Berne Convention as a model and they took that work to be consideration. Now, that is in India, following works are to be categorized. Like, works are categorized: the original work, literary work, dramatic work, musical work, artistic work, cinematograph films, sound recordings. Now, when I say copyright, now copyright means not one thing, but it includes many aspects in it. Now, one by one, I'll explain you what are these aspects. Now, first is literary work. As you all know, literature, writing something. Now, if I write a novel, uh, for example, suppose any novel I write, that novel gets a copyright protection from me, and only I can use that. And suppose if somebody is make, like, fictional or non-fictional, any movie, any novel I make, I have a, like, access to it, and I'll only have the power to distribute it or the power to rent it because it is my work. Then computer programs, the computer programs are included in copyright. That is, the programs which you make are included in literary work. Then next I go to data compilation. You know what is data compilation? The data, that is, compilation of data or material, whether it's machine readable or other form, by any reason of selection of arrangements, contents constitute intellectual creations, shall be protected as such. That is, any data you compile it together and keep it together with you would be a data compilation. Then musical work. You know that whatever musical work, opera is there, then light song is there, choruses is there, musical opera is there, solo singing is there, group singing is there, chorus is there, bands is there, orchestra is there. All these are what? All these are musical work. That is one which relates to music, though it is solo singing, or it is, what do you say, group singing, or it is a band organization, what do you say, a band, an instrument, or what do you say, a performance by any of a person, that would also be included under musical work. Then I go to artistic work. Now, this is something very different from others. That is, it does not relate to data compilation, neither it relates to writing of novels, nor it relates to musical works. It relates to drawings, paintings, ethics, lithographs, or like 3D sculpture, 3D sculptures, architectural work. Then, what do you say? Something which shows you an art, artistic work such as painting, sculpture, drawing, diagram of a map, chart, plan, engraving, photograph. See, what I'll tell you, whatever creative ideology you do, whatever creation you do, whatever pictures you draw, whatever drawings you draw by your own, has its own capacity. Nobody can steal it from you. Now, suppose you prepare a design. Now, that design is liked by somebody. Now, they can put it in their shop, but not without your permission. Suppose if I draw a beautiful drawing of a child, little kid. Now, that drawing exclusively belongs to me. That picture exclusively belongs to me, and nobody else than me claim that drawing. If anybody wants to paste my drawings in their shop, they have to pay me. Then, like, it would also include engraving, photograph, then work of architecture or other work of craftsmanship. Any craftsmanship work, anything you do. You see, right? People prepare a statue with a sand, way back 2 3 years back or 5 years back, to be precise. Man made a statue of Dr. Abdul Kalam, APJ Abdul Kalam, in the beach side. where no, it is his artistic work, it is his architecture. Nobody can steal it from him. It is his own work. Now, next is photograph. Now, photographs like photography, photolithograph, and any work produced by process of analogous photography but does not include any part of cinematograph. Suppose I'm a wildlife photographer. Whatever photos I click, now, see, if you come across wildlife photography, it's a very dedicated and complicated work. Now you have to dedicate yourself. You have to take pictures of those birds or animals which are very rare, or which like those instances which are not normal, those instances which you can't see. Now such kind of pictures are worth millions. And if you take such pictures, now these are only to you, nobody else can use your photograph, and it is a photographic protection to you. If some, like, you have a photo and somebody else has used your photo, you can file a suit against them for infringement. Then next is motion pictures. As you all know, motion pictures means films, dramas, documentaries, newsreel, broadcasting, live cartoons, technical process, pictures, transparent film, electronic videotapes, etc. See, whatever I do, suppose if I do a documentary, even that documentary is my invention, my cinematograph, my motion picture. That documentary cannot be used by anyone without that particular person's consent, because that is a cinematographic work. Nobody else other than him can use the film. For example, there is a music in a particular film. Now, that music cannot be copied in some other movie, or there is a scene in a movie. That scene cannot be copied in some other movie without the consent of the director or the producer. So, if at all you are doing something, you have to take consent of the other party. If you don't take consent of the other party, then there will be a big problem. Then the other aspects, that is, which are now covered under copyright, is works of applied art. If anybody knows, no, jewelry. Now there are different designs you make. The wallpapers are there, their lamps are there, their furnitures are there. Like there are different designs are made to it. Now those designs also are protected under copyright. But there is already a new addition to copyright laws. Now, hope I'm clear till here. Now I proceed to rights to be included in copyright.
Sir, I would like to ask one question.
Yeah.
Sir, like as you said that copyright, like anything you want to use, so they have to, like maybe you are explaining a picture or something like artistic diagram. So then the concerned person has to pay for something. Otherwise, you can put a case. So that is the one thing. If you take a permission,
Now, see, if the person himself gives permission, now that then that's not an offense. But if
then
you don't take permission and if you use it, that amounts to infringement of copyright laws.
okay.
See, whenever you take permission, somebody asks permissions. That person who created that copyright, suppose some song, some movie they have created, you have to pay them some money as royalty. Only when you pay them that money, you can use the material. Otherwise, it's an infringement.
What is the royalty percentage and also
That depends upon the author, the person
author?
who made it. Now, he'll decide what is the percentage of royalty he'll take. But royalty annually is a money which will be paid to you for your invention.
Sir, one more doubt I would like to ask. So I have like different documents I have customized. I have made it my own guidelines for my own organization. So can
Okay.
it be a copyright?
No, like ideas are never been copyrighted.
No, no, not ideas, sir. Like a different maybe guidelines. There may be IPBP, intellectual property and business promotion in a particular organization. So I have taken a different ideas, maybe guidelines, not ideas, guidelines or information. I customized it my level, my our organization's sake, what it can be.
Yeah, yeah. Now, if it is only for your organization's sake, nobody can take it. If anybody takes it, you can file a suit against them.
Ah, okay. Then thank
Provided,
you.
provided you have to prove that you are primarily using it and somebody took it from you without your permission.
Fine, sir. So, what is the procedure to put a copyright? Can you put a logo like that, like a copyright C, copyright in all sense, like a
No, 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 no. You have to obtain a copyright license from the board. There's a copyright board.
copyright board?
Take
Okay,
care of all this.
okay. Thanks.
Okay, now rights to be included in copyright. Now, when I have a material, now what kind of right do I have with it? Now, see, if I sing a song, I can have multiple copies of it. Only I can have. So, because see, if I make something, it's my song. I may like to listen to it again and again, so I can reproduce it. Then, reproduction rights. Other than me, nobody else can reproduce my work. There is section 2x defines what is reprography, reproducing, recopying. That is, reproduction right is only limited. Limited to whom? Limited to a person who has made such a performance or made sang such a song. Now, next is performing rights. See, for example, I give an example. Arjit Singh sang a song. Okay. Now it is Arjit Singh's song. Can anybody else sing that song? No. Because it is their performance. Nobody can steal their performance. Now, like the question of performance came into picture from 1994. Now, who is a performer? Now, when I talk about performer, an actor, like which says the section 2QQ defines a performer. Now, who is a performer? Performer is an actor, singer, musician, dancer, acrobat, juggler, conjunture, snake charmer, anybody. That is a person delivering a lecture or any person who makes a performance. Like any visual or acoustic presentation by a person. Now, you see, many of you don't know snake charmer. Like there are snake charmers in the world. By this, I remember like the old quote said by Britishers: "If we ever left India, like India would be run by goons and snake charmers." It was a quote by a Britisher like who ruled India. The other part, snake charming. Snake charming is also an act of performance. Actor who is acting in a movie, singer who is singing in a movie, musician, dancer. This choreography and all. Have you come across choreography like learning the art of dancing? Now, this is also a art of what is it? This is also a person of copyright, juggling. Who does it? All this, any person who delivers a lecture is also a art of copyright. Next is recording rights. Now, see, for example, recording. Uh, I am a I'm a musician. Now I want a different voice to my music. Now I am recording a sound which is of a bird and which comes once in 10 years. So I go there, I sit and I wait for the bird sings, and I record the voice of the bird. That is what? That is my recording rights. Nobody else can copy that.
Sir, I have a question. Sir, like how come I know how can I know that that particular song or maybe a particular literature is registered in the copyright under copyright.
Before you take somebody's song, before you take somebody's recording, once you go for uh, copyright, they'll tell you like this song is already recorded or this music is already recorded. They'll tell you. They'll not allow you for fresh registration.
No, fresh registration. Okay, okay. Yeah. Otherwise, we cannot see like any library that I can
No, no,
only in
no.
the registration board only.
They're trying to make one data, like one IP
Database.
database, like patent PCT,
Yes, sir.
patent cooperation treaty. Like
Okay.
this, they are trying to make one database where you can find everything, but it is practically not possible because it is very cost consuming. So they are not trying to put such a thing now. But,
Okay.
but presently, there's no any software to identify this.
Okay. Thank you, sir.
Next is cinematograph rights. Now, cinematograph is it's a movie. Any work, visual recording, or any medium through a process from which a moving image may be produced by means includes sound recording. Accompanying such visual recording, cinematograph shall be construed including any work produced by process of analogous to cinematography, including video films. Let us see cinematograph. What is cinematograph? I make a movie. I make a cinema. That cinema is my production. The director is a person who directs the producer is a person who produces that movie. So all of them, one sec, let me admit. Okay. No, all of them are the part of cinematograph film. The like suppose I copy somebody's movie, which is there. Now that is my right. But now if I copy, then I've infringed their right. The director can file a suit on me, or the producer can file a suit on me because they've invested a lot in that movie. And it was their idea. Like movie is an idea, right? Like watch, suppose I may uh, time and time again they are making same kind of movie, the hero heroine, there's a fight scene, the hero fights with the villain, like the hero wins. These are common paradox. But like then if you make a movie which is very artistic, very real, for example, let me take Tare Zameen Par. Now, Tare Zameen Par is a movie which was made by, which was acted by Amir Khan. Now, that movie was very different from other movies, the commercial movies you have. It was very different a movie than the commercial movies. Now, that movie will have a copyright to it. And nobody can make a movie like that. Like if they want to make a movie or anything they have to make, they have to take permission from the director of that movie. So that's why cinematograph has its own right. Next is broadcasting rights. Now broadcasting means what? A wireless signal emitted into the air which can be received by a person within the range of the signal possesses equipment, radio or television receiver necessary to convert the signals of sound and sounds in image. That is broadcasting regard to what? By means of, that is as regard to communication to public by means of wireless diffusion, whether any one or more forms of signs, sounds, visual images. For example, the broadcasting rights. Suppose Z had the broadcasting rights of the current World Cup. No other channel than Z can show the cricket match. For example, Hotstar. Now Hotstar takes the broadcasting rights. Now only Hotstar can show that, and nobody else can show the cricket live because they have taken the broadcasting rights. So they can only broadcast the cricket. Nobody else can broadcast the cricket apart from them because for broadcasting also, for telecasting signals also, you pay to the government. These are media rights. Now only you can broadcast it. Now for that exclusive broadcast also, they pay some money. That is what broadcasting is. and like rebroadcast. Uh, if anybody watches serials and all, these serials, the person who makes serials, they can rebroadcast it on their own channel, not in any other channel. For example, you've seen a cricket match. That channel has the right of broadcasting as well as rebroadcasting. Next is translation and adaptation right. Now, what is translation? For example, there's a movie in Hindi. Suppose the same movie has to be taken in Marathi or Telugu or Tamil, any other language, then they have the right to do it again. The same person, like the translation of the original movie to some other language. Then, translation one to other. Now, adaptation is changing the course of it, adapting. That is, adapting means what? There is a novel I have adapted into a movie. For example, uh, A Walk to Remember. A Walk to Remember is a novel by Nicholas Sparks. That novel is being adapted into a movie. If you see, that it is a novel which is written by Nicholas Sparks. It's a love story between a man and a woman. The same story has been portrayed into a movie. That is where what you call as adaptation. You adapt a story in a novel into a movie so that people watch the movie. That is what I call as adaptation. Now, when you do adaptation, no, you have to pay to the author of the novel. For example, this man, Chetan Bhagat, filed a case against the director of Three Idiots. He said that you copied my novel, they copied the story in my novel. They didn't pay anything to Chetan Bhagat. Then it was resolved between the director and Chetan Bhagat. Then adaptation. Suppose any drawings are made, you can convert it into drama in front of public. Ramayana and Mahabharata. Like whatever is written in Ramayana and Mahabharata, what they do is they put up stage performance so that the normal people should understand what is right and what is wrong, what is to be done and what is not to be done. To make the general people aware, they put dramas, they put shows just to make you know about the mythological aspects of a particular religion. And by that, they script a drama which is there in a book. Next is moral rights. Now, moral rights means what? Now, see, if I produce something, if I make something, morally that right should belong to me because I am the owner of it. So, a right to claim authorship of a work. If I write a book, now morally, who is the author? I. If somebody else claims, it is immoral. I write a book and you claim it. Is it moral? No, not at all. Because I have written that book. No, if I have written that book, I should claim authorship of it. Nobody else can claim authorship of it. And the second part of it is, I can object any kind of distortion, mutilation, modification, or any derogatory action to the work. Now, suppose I've made a movie, but the same movie has been portrayed in some other way, uh, which may lower my image. Now, if such thing is there, I have a right to object that film because I made it, and somebody else has portrayed it in some other way. So I'll have a right to stop it. That is my moral right. Now, this moral right will be there with you even if he transfers his economic rights. For example, I sell a movie. I sell my movie to 1 minute, 1 minute. I sell my movie to Shivaranjani, for example. Now that movie which I sell it to her, that is where no, even if I sell am I audible?
Yes, sir. Now you are.
No, even if I take economic consideration from the other party, still I have moral rights. You can't tamper with my story to lower the image of the maker. So that is my right. Now, the new kind of right, which has been now introduced, is rental rights. Now, rental rights means what? These are the rights which are like little complex, which has grown complexity in the technology. Computer programs. That is, these computer programs, this cinematograph works cannot be given on rent or cannot be, what do you say, given on rental basis because it maligns with the right of a author. So you can't rent it. Next is neighboring rights. See, I'll tell you. For example, Rohit Shetty is making a movie. Now, I am a singer. I sang a song in Rohit Shetty's movie. Even though he paid some money to me, I'll still have I can still use that song to my personal performance. Well, suppose somebody calls me for a award show, Arjit Singh. Now, Arjit Singh have sung many songs. Suppose if he wants to sing that Ashiki's two song in the stage in the award function, he can sing it. His director or producer cannot stop him from singing it because it is his neighboring right. Only he produced that song, so he can present that song in a stage. Only he'll have a right to it. Next, I go to registration of copyright. Article 44 says that there will be copyright office register, which will be called as register of copyrights, which may be entered the name or title of works, name and address of authors, publishers, and owners of copyright, and such other particulars may be prescribed. That is, there will be a register in the copyright office. That will be called as register of copyrights. In that register, they'll write name of the author, they'll write address of the author, the publisher, the owner of the copyright, or whichever is material, they'll write that information there. Then all the particulars are written. That is, so by Arjit Singh, who is a singer, Arjit Singh, what kind of song he sung, he sung a song like this. Then he has to pay some fees to the registrar. Then his work will be registered. if at all any problem comes. Okay, now suppose I sing somebody else's song. How they can file a suit against me? They can take this register. They can say that I am the singer of this song and I have registered before you, so I can only sing that song and you cannot, because this register of copyright serves as a evidence for the other party. Unauthorized use. Now, unauthorized means what? Without the person's permission, you use his work. Now, by using his work, what are you doing? By using his work, you're taking his right, an unauthorized work. Now, unauthorized means what? The You're doing his work without his permission, without his license. So you can't do it. Summary. Now, next is structure of Indian Copyright Office. That is, there'll be a register which will be which will enter the particulars of a person who wants to register himself. Then there'll be a copyright board. Copyright board means what? The government has set up a Copyright Enforcement Advisory Council, CEAC, that advises the government for enforcement of issue concerning copyright. See, there is no special court for copyright cases. Regular courts can try the case. No, but like normal courts. But before going to the court, no, you can go to copyright board, like which will be having a chairman or two or more, but not exceeding 14 members of adjudicating certain kind of copyright cases. The chairman of the board is level of high court, the judge of high court, and the board has power to. See, there'll be a board, like we have court for our dispute. For them, those who do copyright, no, there'll be a board. To that board, they can file a suit. They can file a complaint to the copyright board. That copyright board will have a committee, a chairman and two members or 14 members. That chairman will have a power of judge of a high court. Other than going to the court, you can go to the court, but for sure, but not before going before the copyright board. If the copyright board does not give you decision in your favor, then you can move to the court. But other than that, there is no special court for copyright. Now, what kind of power will the board have? They can hear appeal against orders of the register of copyright. They can hear application for rectification of register of copyrights, adjudicate dispute on assignments of copyright, grant compulsory license to publish or republish works, grant compulsory license to produce, publish translation of a literary dramatic work in any language after a period of 7 years from the publication of work. That is, after 7 years means what? For 7 years, the producer can use his produce. After that, if it is important for the public to know that, they'll give compulsory licensing. Then, hear and decide disputes to whether the work has been published about the date of publication and the terms of copyright work in another country. That is, they'll hear and decide whether the person has registered or published anything in his own country, or has he published in some other country. Then, fixed rate of royalties in respect of sound recordings under cover version provision. See, royalties, as somebody asked me the question, percentage of royalties depends upon the work created, but only in case of sound recordings, the board may fix the amount of copyright. Then, hear and decide dispute whether as to work has been published or about the date of publication or term of copyright, fix the rate of royalties, fix the resale share, right in original copies, painting, sculpture, or a drawing or original manuscripts. That is, if somebody is copying my work, how much share they should give to me out of the profit they are earning. That will be decided by the copyright board. Copyright board is nothing but a body which will decide copyright disputes, which will contain one chairman, two members, or up to 14 members to decide a dispute. Next, I go to term of copyright. Now, see, the term of every, like there is patent, copyright, trademark, design, everything is of different period. Like the time period for everything is different. Now, the term of copyright runs on two elements. There are two elements to be considered when you are talking about the duration or the term of copyright. The one which remains until the author is there, until the performer is there, the right will be there. Second is it will remain up to particular period after his death. The basically the under TRIPS agreement, they have said that the term is 50 years. But under Indian Copyright Act, there are different categories, different duration is given to different things. Now, copyright, all the categories will come under lifetime of the author plus 60 years. That is up to the lifetime of the author plus 60 years. Up to that, person can claim protection of copyright.
So my point is, if it is an organization as a developed a literatures, maybe a video or anything, then there is a no term.
Now, unless now, if it is an organization, then until the life of that organization, until the organization comes to an end, then after that the period will be counted.
Okay.
Now, next I go to acts which will not be considered as infringement of copyright. That is those acts which are not considered as infringement of copyright. First is a fair dealing with literary, dramatic, or musical work for the purpose of research. Suppose a fair dealing I'm using for a public purpose. Any literary work, any dramatic work, any musical work. For example, I'm an NGO. I'm using a music for poor children's, for like people who are in orphanage home. I give them the music so that they feel good. Now I'm not making money out of it. Just to make them feel good, I'm putting that songs to them. This is what this is. This is what a fair dealing is. Then adaptation by a lawful possessor. If I'm a director, I made a movie in Hindi. Now, if I want to make the same movie in Tamil, I can make it because it is my right to adapt it. Then observation, study, or testing a computer program, I can do it. Then making copies or adaptation of computer program for non-commercial and personal use. That is any copies I make of a computer program for non-commercial purpose. That also I can do it. And a fair dealing of literary, dramatic, or musical artistic work for the purpose of reporting current events in newspaper or broadcasting. Anything now, any event you're doing, any street play you're doing, and there's a video recording by the news channel, it's okay. It is for the fair dealing of the public. so that people can know that such kind of stage performance are done. Then reproduction of publication for other judicial or publication for judicial or other legal requirements. That is for judicial purpose or other legal requirements. If you reproduce, that's okay. Next, I go to industrial property rights, which talks about patents. Now, what is patent? Patent law is introduced by British,
Sir,
which is which is
I'm
more.
Shivaranjan.
Yeah.
Sir, I have one doubt, sir. Sir, nowadays televisions are conducting singing competition, hai na, sir. In that, children are singing A.R. Rahman song or A.R. Rahman round. In that, we have to get the permission from the A.R. Rahman sir. Then we have to sing a song, or how can they will conduct the song, sir?
The show will take permissions from all the people, like all the particular. Suppose if they are singing some song, they have to give it.
Yes.
Like we are singing only this song, and will not be making. No, they are not commercializing that. They are not selling that for money. This is just to encourage the students for public purpose. So if they
Okay,
are
sir.
not reproducing it, no, there's not a problem. If they are making reproducing copies and we are selling it to people, then
Okay,
they'll be under a problem. But if they are
sir.
doing for public purpose, that's okay.
If we are earning something from their rights means we are we are crossing the road. If it
Yeah,
is
yeah.
just
You are
entertainment means it is not, no need
this
to get great, sir.
this is just for entertainment, and there's no problem.
Okay, sir. Same rule for orchestra also, sir.
Yeah, yeah. Same role for orchestra.
Okay, thank you, sir.
Now, patent. Patent is something which you invent, which you discover, something you evolve. That is called as patent. Now, what is patent? Now, Patents Act 1970 is there, and it was amended in the year 2005. Now, patent means what? Patent means any invention. Now, which invention you do? New invention. That is any invention or technology which has not been anticipated by publication or any document in a country elsewhere in the world before filing of patent application with complete specifications. Subject matter has not fallen in public domain. See, something I'm inventing which is not new. Suppose if I invent a phone. Now, who invented phone? Alexander Graham Bell. Now, before him, nobody invented. Now, some after Alexander Graham Bell, there were many changes to the phone to be made. There was wireless phone, there was speaker phone, there was cordless phone. Like there are different types of phones came, but nobody will get in patent. Only Mr. Alexander Graham Bell will get patent because he's the one who made the phone. So he's the one who invented a phone. Now, invent means what? To make a new thing. To make a new thing which is not known to the public. Nobody knows it. Then, like to grant a patent, there are few things to be understood. The invention should be new, and then the product, like the patent which I'm asking for, either it is a product patent, that is I ask a patent for a product, or either I ask a patent for process. Then invention could be in the field of technology, it could be in the field of invention or technology, and it should have an inventive step. Inventive step means what? Which which is not common. which is not known to anybody, then it should have utility, my usefulness. Now, if I invent poison, is it useful to anybody? No, it is not useful to anybody. If I make something which is useful for people, only that can be called as patent. And one which is not, one which is useless, but which is new, what is the use of it? See, if I'm inventing something, that should be new and that should be used by the people. But if it is new but it can't be used by the people, then it cannot be called as patent. Now, like they have been separately defined. Novelty. Novelty means newness, uniqueness. Unique means one which is one which nobody had anticipated, one which nobody had ever imagined that such kind of a thing will come. That is what we call as novelty, new. That is, it does not come to anybody's knowledge. Now, telescope. Telescope, before invention of telescope, nobody knew that we can see the moon from here, or we can see the star from here. So what? This is what the invention is all about. You have invented something and nobody knew about it. No, like before it. Once you invented, people got to know about it. But before the invention came into picture, nobody got to know about it. That's what? That's a new invention, right? Nobody should have anticipated. Nobody should have expected your invention. Only then it can be patented. Then inventiveness. What is inventiveness? Now, along with novelty, there should be inventiveness. Novelty means new, and inventive means one which is more uh, productive and like something very different, non-obvious. Now, see, I throw a glass. Uh, uh, now this glass. Now this glass, if I throw down, it will break. This is what obvious. Ultimately, this will happen, right? But somebody invents something which is non-obvious. If I throw a glass and which doesn't break, this is what non-obvious. I can get a patent on it, which nobody has invented. No, which inventions are not patentable. That is, what cannot be patented. For example, those inventions which are contrary to well-established natural laws. Um the person is smoking cigarette and he's smoking like a ring. Now you've seen, right? People smoke like a ring. Now there's a very unique like design, but you can't patent it. This is not fair. Such things. So it is against the nature smoking. So if you do this, you can't be given patent because it's not a fair invention. Then, an invention which is primary and intended to commercial exploitation, which is contrary to public order or morality, which causes serious prejudice to human, animal, or plant life, or health or environment. For example, if anybody knows, uh, can I invent uh, what do you say? A toy which is naked, though that toy like runs around everywhere, a female toy which is naked. Though I can invent it, but it is contrary to public morality, public order, I can't make such a invention. I can't make such an invention which takes away the morality of the country. Like, you can make a naked woman, but the naked woman, a robot. For example, I make a robot which is a female robot and which is naked. But then you can't make it because it is against the morality of the country. Then, mere discovery of a scientific principle or formulation of abstract theory or discovery of living any non living thing, living or non living substance occurring in nature. For example, any different kind of fish I found, like fish I found, but I have not invented, but I found this fish. No, I can't ask for patent because this was already in the nature. The fish is all. Did you make it? No, the fish got its own life. It was surviving by itself. So in such a case, I can't be granted patent because it was already in existence. Then, a mere discovery of a new form substance which does not result into enhancement of known efficiency of substance, or mere discovery of any new property or new use of substance, or mere use of known process, machine or apparatus, which is knows the result process results into new product or employs a new reluctant. For example, I introduced a phone, somebody introduced a mobile. Now I introduced sound recording in call recording in that. Now, inventing call recording in a phone is not a new feature. Though it's a new feature, but you have not invented anything. It is only enhancement of the product. Video calling is there. Video calling somebody invented. Now, even that is also not an invention. That is in the phone. It was an additional feature in the phone. 4G is invented. No, you can't patent. 5G is invented. You can't patent it. It is an additional, what do you say, process to your phone. Now, new software comes to your phone. That's okay. You can't patent it because it's an upgrading version of a phone. That's it. Then, a substance obtained by a mixture resulting into any aggregation of property. For example, I mix two different muds and I prepare a clay or I prepare a statue. No, I can't take that statue, like, I can't ask for patent for that statue. I have invented a statue with two muds. It is only a real admixture, only a, what do you say, mixture of something. You have not invented anything. Then, mere arrangements or rearrangements of a or duplication of device. For example, my bike was running in petrol. I did some changes to it. Now it is running in battery or running by gas. Now I'll not get patent to it because I have not invented anything new. I have just changed the process. Instead of the petrol which is going into carburetor, what did I do is I made gas to go inside and make the bike start. For example, today, if you buy a new bike, no, there's a technology called spraying. The petrol will be sprayed in your carburetor so that it reduces fuel consumption. So it's a new, what do you say, new advanced technology to a bike, but you can't patent this because it's only a advancement to the known technology. That's it. You have not invented anything new. Plants, animals, seed, variety, species, any biological process. Suppose a, a girl delivered a baby. Can she ask for patent because I've delivered a baby? No, right? It's a natural process. Every human being reproduces, right? Uh, every couple reproduces. There's nothing new in it. So one which is very obvious, one which is a biological thing. No, you can't ask for patent for it. Then any mathematical calculations, any algorithms which are already there. For example, Pythagoras theorem is there. Now this cannot be patented because it is already known. No, I can't change the mathematical calculations and I can ask for patent for it. Next is patent application. First is content. That is kind of information to be presented in the application. What is the invention I'm thinking of? What are the developments I've made? What will the invention do? How it is new? Then physical requirement of patent application. They'll be giving an application. In that application, you'll be writing the specification of the property you're trying to. Now, priority date. See, priority date means what? For example, I invented something and my friend also invented something. I have given the application of the invention on 10th of August. My friend has given the same invention, same application on 15th of August. Now, my application will be considered because I was the one who gave this application first. Priority matters. One like have you heard first come first serve? The person who applies first, he'll get the patent. Then to get the payment, that person has to pay prescribed fees. Then, then what they'll do is they'll make a publication in the newspaper. That is such and such kind of a person is coming to claim this invention. If anybody has objections over it, they can grant objection. Then like they can raise objection. Once the objection is granted, the patent will be opposed. Now, before, like, once it is granted, you can't oppose it. The notice is given to you. There is a advertisement in the newspaper. In that newspaper, you saw something. You already invented something like this, so you can raise an objection. That is called as pre-grant objection opposition. Now, if you oppose it, you can oppose it only when it is granted before. That is, before granting it. After granting it, you cannot file a application for objection. What can I object? That I can object that whatever invention Mr. Abdul is claiming is already invented. Or whatever invention Mr. Abdul is claiming is he has wrongfully obtained. Or whatever invention Mr. Abdul is claiming does not fulfill patenting criteria. Then, like next, I can also say that whatever invention Mr. Abdul is claiming, there is no proper disclosure of the invention, or the known is already the what do you say, the invention is already known to the public. These are the grounds where I can raise my objection. Like if I have any objection, I can raise these objections. Now, now I come to term of patent. Initially, the term of patent were for the period of 14 years. Then now, according to section 53 of Indian Patent Act, like in 2002, the term of patent became 20 years. Like earlier, before 2002, the term was 14 years. Now it is for the period of 20 years. Once you get a patent for a particular product, you can enjoy explore economic exploitation up to 20 years. But in earlier before 2002, it was only for the period of 14 years. See, the date of filing of patent application and the date of grant of patent should be very different. Now, suppose today I'm giving patent application. Can I say today itself I'll get the patenting license, no. The application is should be on a different date from the date of patent, that is the grant of patent. Once a patent is granted, it will be announced in public. There'll be a patent gazette. In that gazette, they'll announce that a particular invention has been accepted by the patent board, and the protection will be granted. Then they'll issue the patent number, the formal publication of patent grant, then issue a certificate to the applicant. What kind of certificate? That is, you are the inventor of the particular discovery, and you'll get the certificate. Am I clear?
Yes, sir.
Next is industrial property rights, which will talk about trademark. Trademark. Now, as you all know, trademark is a mark which you will be keeping for yourself, which will be unique from others, like an identification mark for goods and services. For example, McDonald's. McDonald's gives you M. That M is your trademark. Or like there'll be different kinds of sign, different kinds of brand, label, heading, ticket, names, signature, words, letters, numbers, shape of goods, packing combination, color combination. There'll be single color, multicolor, 3D, hologram, sound moving images. For example, Cadbury, Cadbury chocolate. Now, Cadbury chocolate actually comes in a blue wrapper. You cannot say it's blue, it's purple in color, triangular. That like it'll be like triangular in shape and a purple wrapper. The moment you see that purple wrapper, you'll come to know that this chocolate is Cadbury. That kind of goodwill this has taken. Now, for protection of trademark, there's an act called Trademarks Act 1999. It was 1958. No, yeah, trademarks. The enactment replaced Trade and Merchandise Act 1958. That was replaced by Trademarks Act 1999. It was a colonial law. Earlier, like 1940, also they made a law. If we go to, I'll go to salient features of trademark. Now they've defined what are signs, what are marks. Then I can then exclusion of signs or marks which are distinctive. Distinctive means what? For example, if I am making a chocolate which is Cadbury, okay, then like there's a copy of it Cadbury that is called a G Day. Like it looks exactly like Cadbury. The wrapper is also like Cadbury. The color is also like Cadbury, but it is not Cadbury. They have made what? They have the exact replica of the actual Cadbury. They're trying to mislead the customers. But now these kind of people, they don't go for registration of marks because they are misleading somebody else's marks. Then If you are not registered as a trademark, you cannot seek protection. For example, I sell foreign chocolates, but I did not register with trademark. Somebody else registers with trademark. I cannot go and file a complaint that I was selling before him. Unless you register yourself for trademark, you cannot seek protection for trademark. Then, trademark actually gives a strong protection for consumers against misleading. I cannot mislead the consumers. I cannot cheat the consumers. Then, like there are regulation of collective marks, certification of marks, as well as standards, labelizing. Now, you see ISI. ISI marks a quality, marks a standard. That is a standardization mark, and that will be given only to standardized products. Let me tell you one example: helmets. Helmets with ISI brand, ISI label are much more protective than those without ISI marks. Now, what is trademark? One like a visible sign capable of distinguishing goods and service. It's a visible mark given to you. Now, visible mark. Any visible marks we understand is that Apple. If you get Apple iPhone, no, if you turn that iPhone, there's an Apple half bitten. You cannot say half bitten, partly bitten. But that logo belongs to Apple. Nobody else can use that Apple. Then Tata is there, Ford is there, Godrej is there. There's what? Now, now Apple. Once I say Apple, you remember about a laptop or a phone, Mac. Then a mobile, you will remember. Then I can make fanciful names: Pepsi, Coca-Cola, Kodak, Sony, and so on. Then I may keep a family name. That is what? Tata. Tata is from a family. Godrej is also from a family. Then Ford is also from a family. So like they can keep their family names. Then you can keep a slogan. Pure for sure. Now, pure for sure is a slogan by Hindustan Petroleum, HP. When you go to HP Petroleum now, they'll write pure for sure. That means what? The by looking at that logo only, you'll understand it is HP. So, for example, there was a famous slogan by Air Deccan. Wherever you see color, think of us. That what? The moment you see that slogan, you will come to know that it is Air Deccan. Then there are few symbols which are very what do you say, very unique. For example, you see four circles. Now four circles in front of a car. That means what? Audi. A T in front of a car. That means what? Tata. Then you like a star kind of a thing is there in front of a car. Then it is Mercedes Benz. Now these are what? These are logos which are given to these are symbols which are given to um, their cars. You will come to know. For example, Ferrari is there. There's a horse logo to it. Then um, Rolls Royce is there. That once you put on the button, no, that animal kind of a thing comes out. That is the logo for um, the car, Rolls Royce. Then you can use numbers. If you remember numbers, no, 555. If anybody remembers, it was a washing soap. The name was very known to the people. So where the washing soap of 555. That number have become very famous. Then pictures or symbols. If you see Adidas, Nike, if you see Woodlands, Woodlands will have a tree to it. Nike will have a mark to it. Like these are what? These are the symbols which they use. Then collective marks. What are collective marks? An organization uses, no, it may make many products. It will have one mark. Uh, when you go to McDonald's, they make burger. They'll also have. They make French fries. They make chicken. They make what do you say? Now, for example, KFC. KFC is now giving pizzas. KFC is giving biryani. KFC is giving wings. Everything will be KFC. That is what a collective market is. Now, then certification mark. Certification mark is nothing but standardization mark, which marks the quality of a product. FPO, that is food product order. ISSO, then ISI. These are what? These are the marks of certification. Only when you reach certain level, they will give you those marks. If you don't reach to those levels, they will not give you those marks. ISI. ISI means what? That standard you have reached. So we'll give you that ISI mark. If you don't reach that standards, no, we'll not give you ISI mark. That is what certification marks all about. Next is well-known mark. That is the mark which is known to the people. uh, any mark that is, suppose if I say rupee, the rupee sign is there. That rupee sign is well-known mark, though you cannot use it for yourself, but those marks they use it for the, like those marks which are known to the public. uh, Oil, now for oil is known to public, they'll put it like for water. Now water mark is known to everybody, they'll put a water kind of a sign which is known to everybody, but they'll not give the name. They'll put that mark as soon as H2O, but you'll not name it, but you'll make a big 2 in that water bottle. That is what people know it. The moment they see it, they feel it's water. Then, criteria for trademark protection. How a trademark will be protected, how you will be protected, or how protection will be given for a trademark. Now, how is it protected? Trademark, it is to be different from each other. Then it should not mislead. One, it should be different from each other. Suppose Parley has a mark. The same mark cannot be used by Britannia. Parley uses Britannia's mark. It is misleading. You can't mislead anybody, because it is your duty not to mislead anybody. And whichever mark you are presenting should be distinctive. Like people of normal understanding should also differentiate between the product. For example, I'm an illiterate person. Okay. So I only know that if I go to buy Colgate, it will be red in color. Like red and little white here and there will be in color. Now, that person who is uneducated, but he can differentiate between Colgate and Close Up, the texture, the color, the thickness. Now, nobody should replicate it. Nobody should create confusion in the mind of public. Nobody should deceive the public. Nobody should cheat the public. Now, trademark will be protected for the duration of 10 to 20 years. In India, it will be protected for 10 years. After that, you can renew it with the application fees. And internationally, that is in UK, some other countries, it varies from 10 to 20 years. But normally, the protection you get in India is for 10 years, and after 10 years, you can renew it again. Am I clear? Anybody has any doubts?
Yeah, yes.
Sir, good evening, sir.
Good evening, ma'am.
Sir, in trademark, you said that if we are using one emblem, and that like Benz, for 20 after 20 years, just we will renewal is enough. Otherwise, we have to change a modification in that mark.
No, no, renewal is enough. Renewal is enough.
Till the end, we have to just after 20 years, renewal is enough.
Yeah. Every 10 years, no, you are supposed to renew it.
Okay, okay, okay.
Anybody else has
So
doubts?
trademark can be a name also.
Yeah, it can be a name, it can be a
Like
number, it can be a logo,